morning. Today is January 29th, 2026, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin. Every week, along with Gene Lawler, Michael Schwimmer, and David Shraga, I'm delighted to co-host another wonderful installment, a program designed for mediators, arbitrators, lawyers, and everybody who negotiates. As you likely know, there's no charge for these great webinars. Rather, we ask people to contribute to a food bank if they like what they see. And since we began the series way back in 2020, our audiences have been so generous in donating in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our audiences have contributed since the series began. Gene Lawler, would you please do the honors?
With pleasure. Good morning, good afternoon, good evening, everyone, wherever you are, whatever it is where you are. I'm so excited this morning to be able to share that we have received notice. People have advised us of having donated 930,000, so that's 930, $305.44. So we're almost at the $950,000 mark, and that means what? $1 million is right behind. So thank you all so much for your generosity.
That is fabulous. Thank you so much, Gene. And we have another wonderful presentation today we hope will motivate people to contribute. Litigation funding and mediation. The rapid growth of litigation funding has transformed modern dispute resolution, particularly in complex commercial matters. Once viewed as a niche financial tool, third-party funding has now become a strategic component in high-stakes litigation and arbitration across the globe. But what happens when funded cases enter mediation or settlement negotiations? How does the presence of a financing partner alter risk assessment, negotiation behavior, timing, and outcomes? Jonathan Stroud is going to explore these critical questions and more with us today, offering practical insights for mediators, litigators, in-house counsel, and all ADR professionals. Jonathan Stroud oversees Unified Patents, legal and corporate functions, managing a diverse docket that spans PTAB proceedings, district court and appellate litigation, contracting, licensing, settlement negotiations, and general corporate matters. Before Jonathan joined Unified Patents, he practiced as a patent litigator at Finnegan, Henderson, Faribault, Garrett, and Dunner, LLP, and before that served as a patent examiner, specializing in implantable medical devices at the U.S. Patent and Trademark Office. Jonathan holds a JD with honors from American University Washington College of Law and earned his bachelor's degree in biomedical engineering from Tulane University, along with a master's degree in print journalism from the University of Southern California. Jonathan, we're so happy that you're here today. Please tell us a little bit about the food bank to which you'd like people to contribute if they're in a position to do so. And then on with the presentation. The floor is yours.
Sure. So my favorite charity and the one that I've selected today is Martha's Table. Martha's Table is an organization that started as a way to keep kids occupied after school with hot meals, and it turned into a sort of DC spanning mission where they pass out food to the homeless and feed millions of families every year, or millions of meals are passed out every year to hundreds of thousands of families in the DC area. It's where I volunteered in law school, passing out sandwiches in the DC area, and I think it's critical sort of in the nation's capital that we do everything we can to fight food shortages, especially when it's as cold as it is this weekend. I feel like it's a especially good time to remember that there's a lot of people that can't eat. So it's near and dear to my heart, and it's also local to my my neck of the woods. So I'd appreciate any donations that are made.
Fabulous. Thank you.
I'm happy to talk today and share some slides and some insight into litigation finance. Litigation finance is one of those things that is often talked about, but the details are light. It's by its very nature something that it's not exactly clandestine, but it's something that there isn't a lot written about, and certainly not a lot disclosed. And sometimes the fight over disclosure and who is funding what can dominate the narrative. But I think it's fascinating to look at it through the lens of mediation, and I have some stories to go along with that. So the joke from The Naked Gun is he asks Lieutenant Drebin, right? He says, "Do you gamble, Lieutenant Drebin?" And he says, "Every time I order out," right? It's one of my favorite jokes from that movie. I'm not a gambler, but some people have likened high stakes investing in all sorts of alternative dispute investments to gambling, right? And effectively, you're making a bet on the outcome of litigation. This is what insurance does on some level. It's an outcome on an event, right? And it's trying to hedge for that risk. This is what all types of PE investing do. You're sort of making a bet on the future success of a company, and litigation funding is that sort of times 100, right? I don't know if you've seen the movie No Country for Old Men, but there's this villain in No Country for Old Men. He's really not a villain. He's sort of a neutral character, but he's the enforcer. And his menacing thing is that he asks people when he meets them, "What's the most you've ever lost on a coin toss?" And he flips a coin, and they'll either live and things are great, or he'll kill them. It's like the most dramatic plot device that you can have. So um, I think there are no higher stakes than there are in that movie, but I think litigation funders would have a lot to say about what they put at risk, because what they do is offer non-recourse loans. They'll offer sometimes small amounts of money, sometimes very, very large amounts of money for $50 million to fund a litigation all the way through. In some cases that have been reported internationally, as much as $500 or $600 million for class action lawsuits, contingent on the outcome of that case. If the case fails, or if there's no settlement, there's no recovery, right? So they are even gutsier than the folks in these movies who are wagering it all on a coin toss. But obviously, it's an attempt to take those binary outcomes, those coin toss outcomes, and hedge risk, allow people to make riskier bets, try to get some sort of actuarial value out of these disputes and drive them forward. But like the financialization of any decisions that are not at base always financial, it does present a lot of problems. And it particularly presents problems in the context of settlement and mediation, because it can change and distort, private equity likes to call it alignment, but it can change and distort settlement. It can change and distort the value of cases, or the perceived value of cases, and it can also impact the decision makers in ways that will affect mediation that we'll talk about in a moment. By the way, I want this to be a dialogue, and I'm more than happy to be interrupted or answer any questions. So, what is litigation funding? I kind of already said, but litigation funding at bottom is a non-recourse loan contingent on the outcome of the litigation from a third party, generally a party that claims no interest in the outcome, although they clearly have a financial interest, right? So what does that mean, right? That means that if the case is unsuccessful, or the settlement is for less money than the entire cost of the litigation that is paid out, the loan itself, they will not be made whole, right? They have no collateral. There's no collateralized debt. There's no mortgage against assets of the company. It's just a loan that is contingent on the outcome of litigation. Um, so I like to call this the triangle. It's the easiest way to understand it. But clearly, when you have a client and you have a lawyer, there are very sort of simple, understandable client-attorney privilege. There's ethical duties to them, and then there's the two-party system. When you add into that the fiduciary interests and financial interests of a litigation funder, who generally has an agreement both with the law firm and with the client themselves, and when the litigation funder is the one who is basically taking all the financial risk in the case, even if by the nature of the agreements they don't control the outcome of the settlement, the agreements are generally structured in such a way that there's a heavy amount of influence over the outcome, and it can distort settlement principles. It obviously changes the sort of point at which settlement becomes beneficial to all parties. And there's a waterfall that we'll talk about in a minute, where the money flows at certain times and at certain levels. And that's very important to understand from a mediation standpoint, because it radically alters settlement behavior across the board. I've been at a couple of conferences where I've been presenting on this with litigation funders, and one thing I found interesting was the number of sitting judges and JAMs or other mediators and arbiters who have kind of jumped up with their anecdotal stories of cases where they thought the parties should settle, and they'd done a lot of work, and they got the parties together, and they thought they understood the sort of right number to settle at and put them together, and the parties just didn't and couldn't, and they couldn't understand it. And in some of those cases, it turned out it was because there was litigation funding, and those funders weren't in the room or part of the mediation. And that was very frustrating to the judges and mediators that were raising these issues at this conference. I'd imagine that this is something that is going to be repeated often in the future, because litigation funding is something that is, if not dominating, then at least starting to be prevalent in over a third, some estimate, of all civil cases these days. You can fund divorce proceedings, you can fund IP proceedings, antitrust proceedings, civil forfeiture proceedings, bankruptcy proceedings. You really can fund anything that a funder will shell out for. And because these are already high stakes cases, generally with a lot of money on the table, distorting the settlement may make it even harder for mediators to kind of figure out how to do their jobs.
Jonathan, but excuse me,
Yeah,
before you go on, I just want to make clear, uh, whose interests do you represent in the conversation,
sure.
and what exactly is Unified Patents' role in the whole ecosystem of litigation and settlement?
Yeah, very, very good. I should have started with that. So, Unified Patents is a membership organization that is defensive in the patent space. We have members that come in, and we file challenges to patents that we think are objectively invalid, administrative challenges, share information, do data work. Most of our members are on both sides of the V, but in the context of Unified, they're defensive. So, you can think of us as a risk avoidance mechanism. Our interests are clearly on the defensive side of things. So I'm trying to be as objective as possible today, but that with that frame, I'm more than happy to concede that that is where I come at this issue. In terms of settlement, and in terms of litigation funding in general, we don't do direct negotiations, so I'm not in these negotiations myself. But what I've seen over the last 5 to 7 years is, at least in the patent IP litigation landscape, outcomes changing dramatically as people ramp up and more cases are funded. And it's starting to really impact all types of cases, all types of behavior. And I think it's just fascinating. So it's something that I've become a mini expert on in terms of writing and speaking and learning about it. And I think it's something that we could all benefit from understanding. It's a great question. So litigation funding used to be here and internationally the hat trick of no-nos, right? A hat trick is when you score 3 goals. And it used to be a crime, a tort, and an ethical violation in every major civil jurisdiction, Australia, the United States, every state in America, in England, going all the way back to the 1600s. And earlier, as soon as there were civil courts where you could sue for money damages, lords started paying people to sue other lords to harass them, right? And so there was a body of case law that developed, and a body of regulation that developed over hundreds of years. That has slowly, I don't want to say disintegrated, but that has slowly changed over the last 100 years. Obviously, the introduction of contingency counsel was something that was of relatively recent vintage. It didn't really exist in the 1800s. It does in the 20th century and has since the early days of the 20th century. And as contingency arrangements became more and more commonplace, and as interest groups like the NAACP and other groups that were sort of bringing litigation on behalf of their members became more and more common, and just as financial instruments became more complex, the old sort of prohibitions against it broke down state by state, country by country. Australia sort of was the first to, if not legalize it, then not outright ban it. And litigation funders flourished there for a while. There was a law in England that changed things that made it sort of permissible on its face. And then now in the United States, there's no federal regulation one way or the other, but almost every state in the nation has either moved away from champerty and barratry and these sort of common law torts in their state courts, but also some of the states have moved to actively regulate it. There's about 18 states that have some form of active regulation of litigation finance, sort of recognizing the primacy of it. And the market has obviously responded as well. So initial reports from, these are private sources, suggest that the litigation funding, US litigation funding, in the civil justice system, top $16 billion a year in funding. These are just some of the names of groups that all they do is litigation funding for the most part, or they have very large funds. Some of them are publicly traded, and you can actually look at their investments and their investment materials, like Burford Capital. Litigation funding is all they do. Funds and financiers have proliferated, particularly over the last 5 years. You also see a lot of known funds like Davidson Kempner and Fortress that have sidecar funds that do litigation funding as well. And so it's becoming more and more common to see litigation fund pools of investment, and there's more and more competition amongst litigation funders looking for good investments. So it's easier to obtain litigation funding than ever has been before for meritorious civil cases. Just looking at patents only, because that's my lens, these are some examples of some of the fund sizes and fund names, just to sort of have people have some context. Fortress is on their third fund at this point for IP specific matters. It's topping $1 billion. Magnetar has a very large fund that a big piece of that is litigation funding. You see others as well. Centerbridge Partners, Starboard Capital. I don't need to bore you with that. In the non-IP space, to expand it out here and internationally, all types of matters have been funded. There have been class action cases brought by the NFL for concussion. Those were funded. There have been cases in the UK against the postmasters for back pay, cases against MasterCard. A lot of the Dieselgate claims were funded. There's been a fair amount of funding of large-scale environmental toxic torts internationally. And sort of the list goes on and grows every year. A lot of the privacy cases in the UK are funded, and in Europe are funded. And I've been told recently that most, if not all, of the class actions that popped up against the AI LLMs, the sort of 63 or 64 class actions that have popped up in the last 3 to 4 years, almost all of those are funded, or at least have one party that is funded. So the rise of litigation funding has led to a rise of more class action and mass tort cases than there were before. And it's something that's going to be common in lots and lots of cases. So importantly for mediation, I think it's important to have a basic understanding, and this is a very dumbed down version of a litigation waterfall. It's not meant to be exhaustive. People structure their agreements and their financial arrangements differently all the time, but it's important to understand. So when there is recovery, right, usually there's a certain amount of litigation and law firm expense that goes into that. Maybe the law firm spent $5 million and a settlement was reached that was a $28 million settlement, right? The first thing that is paid generally is the law firm and all expenses. So any filing fees, expert fees, and the law firm will be paid in their entirety. Sometimes they're paid super hourly rates, depending, and sometimes they have a success kicker, but that's separate. The second person that tends to get paid is the funder in terms of the profit and percentage that they've been given on the top of the total settlement that makes them whole. They'll have some agreement where they're paid back. Sometimes they're paid a flat fee and then a percentage. The percentage can be upwards of 70% of the remaining fund. And then at a certain point, the claimant is paid back. And I think this is critical. It's highly simplified. It's going to be a lot more complicated than that. I'll get into that in a minute. But there is a break-even point underneath which the fund makes no money, and there is a break-even point underneath which the claimant who is making the ultimate decision makes no money, right? And so what that does in a lot of settlements is it can it can inflate the settlement behavior of the party to say, even if you, as the mediator or a judge or the two parties in front of them, should be settling for X reasonable amount on the value of the dispute, there's now sort of an artificial break-even point or an artificial point built into the agreement. Sometimes the parties have done a very good job, and that point is exactly the value of the settlement. Sometimes it's higher, sometimes it's lower, but it will change behavior in settlements based on that sort of break-even point and then based on what they need in terms of the way to make the fund successful.
So, excuse me, Jonathan, is this in principle, is this really any different than what we see conventionally with contingent fee lawyering in a personal injury or employment discrimination case, where the client may look at it and say, well, gosh, my lawyer gets 33 or 40% or whatever, and then I
Yeah,
have to pay income taxes on it, and I have to pay my lawyer's costs. So when you get done with everything, there's really not that much left for me. I'm going to roll the dice and go to
sure.
trial. Is it really that different than what we've been seeing forever?
It's different in two ways. It is similar in that way, but it is different in two ways. One is that contingency fees are tightly regulated and capped nationwide now at this point, federally and at the state level. Various states cap them at different ranges, and they scale generally with the outcome, right? So usually the claimant will make something, right? It may be less than they want, or it may the lawyer may be getting more of it, but generally it is the contingency fees have to be contingent upon the outcome, and they have to be some percentage of the outcome. Usually 33% or less is all that the lawyer can make. It depends on the state, obviously. And so what that means is that the claimant will get something all along the way. The lawyer will get something all along the way too. Now, that has in the past, and people have written about this ad nauseum for the last 100 years, um, meant that the law firm has a vested interest in pushing the case further and higher in some cases. In some cases, they don't because they're not going to get paid. And so in some cases, it's the alternative. They are pushing low settlements to their clients because they need to make recovery and they don't want to be sort of in the hole. Right. So there's a lot that's been written about the ethical duties of the lawyer in the contingency context. It gets a little more complicated when both the lawyer and a third party funder have fiduciary duties and their own personal duties to keep the firm running and make money and all of that. And those interests can diverge from the claimant's interest. So in private equity parlance, they call this alignment, right? A well-written litigation funding arrangement should keep all three parties aligned. It should mean that the law firm has the same interests as the client, who has the same interests as the financial institution. But as we'll see in some examples I have here later, they do break down, right? And that's sort of really critical for a mediator to understand because there's going to be cases where you're mediating a case and your client, the client or the plaintiff's interest is actually divergent from a third party funder that may or may not be present, and you may be called in to mediate that part of the dispute in some way or bring them in because it's changing behavior. So um, it's sort of like the difference between having one roommate versus two. It just exponentially multiplies the potential conflicts, and it does make things a lot more complicated. It's a great question. So this is just another way to show that. But the exemplary breakdown, claimants generally, even in the most successful outcomes for them, make 50% or less of the total outcome of the case. Part of that is because legal fees are so expensive. There have been cases where clients have sued the firm or funders have sued the firm for overbilling. There have been cases where the firm has sued the funder, claiming that they did not fund them appropriately. And there have been cases where the funder has sued the claimant to try to get them to settle or to try to prevent them from settling because their interests have diverged. Most of those are governed by mediation and arbitration clauses as well. And so you don't necessarily see all those, but mediators may at some point be confronted with cases or be mediating cases that are literally between one of these three parties. So it's really important to understand the dynamics too. There's a lot of different models of funding. Some are treated like a private equity, buy companies, assert their IP or bring their claims. Maybe the value of what they have is their toxic tort claim or whatever it is. Um, some do something different. All of them are premised on the idea that they, like a private equity group, can beat the market. They have no liquidity, right? You can't take your money out, but you can hopefully make 3 to 4 times your multiple on invested capital over 5 to 7 years. Now, some of these investments have dragged on longer because it's very difficult to predict settlement behavior of parties and the outcome of litigations. Some of them have been wildly successful. So it's a little bit more of a risky investment, even for someone that's investing in private equity with long hold periods and all of that. So litigation funding is a growing industry, but it's still seen as a somewhat high risk, high reward area. Another example is an arm's length relationship, which is where the funder, in this case Burford, claims to have no interest in any of the underlying litigations. These are cases that they funded. Some of them are international arbitrations between sovereign nations, like the country of Argentina. Some of them are pharmaceutical cases. Some of them are, one of them is a divorce, a very large scale divorce worth a Russian billionaire that was worth upwards of $200 million. So Burford, a lot of this because they're publicly traded, eventually is disclosed, which cases they're funding. Very interesting. And then there are portfolio deals, which is where a firm partners with a funder to say, the funder will fund 10 or 15 of your cases. Sometimes the funder brings them to the firm, sometimes the firm brings them to the funder, sometimes it's a mix. The idea is if some of those cases inevitably fail, right? They just run into problems that are unforeseen in the litigation and the settlement ends up being zero. So they lose all their money in one of the 5 or 10 portfolio cases. They make it back up on some home run that's inside of the portfolio, right? It's another way to spread risk across cases. There are a few firms that are kind of notorious for this, like Sussman Godfrey has been very forward and forthcoming with the fact that they engage in portfolio funding, but there are lots of others as well. And you start to see some of the same large litigation shops engage in this. One of the things that comes out on the other side of portfolio funding, because it's a relatively new occurrence, is there are now cases where firms have had to be taken over or firms have had to sort of engage in downstream litigation about mismanaging the funds of the funder across the portfolio or what have you. So there's been some interesting questions of the independence of the firm and the independence of the funder in those cases too. And then there's sort of multi-jurisdictional funding where you fund cases here, in Europe, overseas, maybe in the ITC. This is just one example. This was a $49 million case where they funded German cases, ITC cases, and cases in the district court here. In that case, because the documents were disclosed, there was a very specific waterfall that changed by phases. This is just to give you a sort of flavor of how complicated these great agreements can get. And then at the end of the phase, if there was a certain milestone hit, there was a kicker that went back to the law firm. So the law firm was sort of incentivized to get to a certain point and be successful enough in the case to make above a certain threshold. They would then make above their hourly rates. This is Sussman Godfrey in this example, if successful. I should add this case was not successful, so they did not hit that fee, is my understanding. But it led to satellite litigation between the funder and the claimant, who settled for less than what they thought was what they deserved, because then it fell to below one of the threshold lands. So how does this affect mediation, and why are we here? So mediators are probably, you'll tell me if I'm wrong, but they're primarily concerned with parties' behaviors, motivations, getting them closer to settlement, trying to understand the two parties almost more from a financial, business, and emotional standpoint than from a legal standpoint, because the goal is to try to obviate the need for litigation. What I have heard is that litigation funding, if it's not disclosed to the mediator in particular, can make that a much harder lift or a heavier lift for mediators. And so mediators should be aware of how it can change parties' behavior so they're not surprised when they think they've done everything they can and the parties have gotten to the right number, and the claimant stands up and says, I don't have the authority to settle this, or this just doesn't work for us. And it seems irrational, and it seems not based in any of your sort of experience. And this is a story that kind of comes up again and again. So I said this earlier, but you can mediate any part of these disputes themselves. You may end up getting into mediations in the future between a litigation funder and the lawyer, or the litigation funder and the claimant, or the claimant and the lawyer, right? In some cases. Those are going to be complicated, but probably easier to comprehend because there'll be an agreement in place. There'll be some dispute between the parties, and at least you have everything on the table in those cases, right? Probably most important, and probably the biggest takeaway for people here, is sort of what are the rules. Now, most states and district courts have a patchwork of disclosure. Some judges require disclosure up front, federally and at the state level, and some states require disclosure in federal court. Most at this point, although it's arguable what you mean by most, national and international arbitration bodies now require disclosure of litigation funding in some way, shape, or form. Sometimes it's the presence of funding because it may influence things. Sometimes it's the presence of funding and the identity of the funder. Some of them require the funder to be present. Most of them require it for ancillary reasons like costs, or if it's an international arbitration, they're concerned about recoverability, right? Things like that. Those same bodies that have mediation wings or separate mediation bodies, there are almost no rules requiring disclosure or even suggestions requiring disclosure, at least so far. Now, mediators have a lot of latitude, although a lot of this is voluntary. Some of it's contractual, some of it's voluntary. And my understanding is that parties can, if they so choose, craft agreements that sort of demand disclosure of anything inside of the mediation, at least to the mediator, right? Litigation funders tend to be very concerned about disclosure of the mere fact that it's funded to the defendants or the counterparties, on the premise that it's going to lead to harassment and discovery, or that it's going to change their settlement behavior, that it's going to give the other side some strategic advantage. But these things do tend to leak out in some percentage of the cases. So there's going to be concerns around that. But by and large, there are no rules about disclosure. So it will be probably the exception and not the rule that there is upfront disclosure or the presence of litigation funder at mediation.
So,
Yeah.
Jonathan, excuse me, from what you've said, isn't it more in the category of a known secret that if you're dealing with certain kinds of cases or certain law firms, that there is a funder involved?
Yes, I think what we're seeing now is until there's some sort of mandatory disclosure across the board, or parties start to realize that it's in their best advantage to disclose, because they do that sometimes as well, right? It obviates a I can't pay, or a David and Goliath story, or sometimes they have to disclose to show that they can pay a cost if it comes through. I think there are certain classes of cases where experienced practitioners or people that see it all the time start to just assume it's funded. I've heard this from judges who are in courts that have lots of business disputes where they say, I just know that this firm almost always has funding based on their behavior, right? Or based on, in previous cases, it's been disclosed. There are certain fund and firms that are kind of more open about it, right? They embrace it, and they see it as a badge of honor. And so you start to get the sense of who's funded and how. In the patent context, most patent cases are brought through LLCs, that are sort of propped up holding companies that just hold the patents and assert them, that are tax advantaged. A lot of times you can easily trace ownership back to a funder that way through some kind of lien system, or what have you. So there's a lot of ways that parties can figure it out. There's also a lot of ways mediators can find out if they're looking for it. But what you what we're trying to avoid is a situation where mediators do a lot of work and the parties come together, and you have the client, or so you have the plaintiff and the defendant in the room together, and you do all this work and you get to a really reasonable number, and the claimant just says, I don't have the authority to settle this, or the parties that should be here are not here. Alternatively, I've heard this come up a lot. It's often the case that funders do want to attend mediation and do attend mediation, not necessarily disclosing who they are, what their interest is in the case. So there's times where they are present at the mediation. And I've heard judges and mediators say, I have just straight up gone to them and asked them, are you interested in this case? Are you funded? Because I need to talk to you, and tried to order them to do that. It can be voluntary if it's in mediation. Sometimes that doesn't work. Obviously, nothing's more frustrating to a decision maker than being in the dark, right? And so sometimes parties figure out a way to disclose that in camera, ex parte, so that one side doesn't necessarily have access to that information, but the mediator or decision maker does. And there are proposals being floated federally and at the state level for sort of in-camera review of these types of agreements, or even just disclosure of the presence of funding to the decision maker so that they know. Long story short, though, in mediation, you should always check, and it may change, right? Because mediation bodies, like arbitration bodies, are changing every day, and they're starting to become more experienced with this. But as of right now, there are very few rules that govern any sort of organized disclosure in mediation. So why is it relevant? We've kind of covered most of it, and I don't want to belabor it, but like whether there will be disclosure or not, obviously very relevant, because you don't want to inadvertently disclose it to the party if that's somehow violating an NDA. You need to know for settlement influence if it's going to impact your work product as the mediator, to try to understand what their actual like financial cliff is, or their actual decision points, or what they're actually trying to get out of the dispute. Um, you don't want to spend a lot of time trying to get the defendant to issue an apology if what's really on the table in that particular case is just a certain number, right? It will obviously impact party behavior, and so it's good to know so that you can sort of understand where the parties are coming from. It may affect deal timing because there may be a time to money component or a cliff based on how much is being spent in the litigation that you're not aware of. So there may be settlement pressure coming from the plaintiff that you don't understand, right? And that may be because they need to settle before they spend a certain amount of money, because at that point it's like sort of throwing good money after bad. They've analyzed the case and they think it has a 6 month to 12 month window, or they need to return something in their fund, and so there's some outside pressure. It can change the case value, obviously, if it turns out that $50 million has been invested in the case up front, expecting a 3-time return, and the parties are presenting to you that it's not worth anything near that, then it can obviously affect your appreciation of that. And then clearly conflicts can arise where there might be a mediator who is directly invested in a fund somehow, especially when general hedge funds start to get into litigation funding, right? Or they may know people on the other side. There are judges that require disclosure because they've worked for Burford in the past, right? And that will start to happen more and more where people have had clients that are funded or have worked with funders. And so these things will be important kind of just to avoid the appearance of evil. So tips for plaintiffs, right? The agreement is king for all of this. So funders need to make sure that they carefully craft and try to predict everything in terms of underwriting the agreements, trying to ensure alignment, making sure that they have some insight into what's happening in the mediation. They probably would like to help control the narrative, and so they need to be very close and aligned with the plaintiffs. And they need to be open to really complicated and tiered settlement options and things like that so that they can be fully aligned on phases and they don't sort of force one particular outcome and try to fit a square peg into a round hole. And yeah, plaintiffs also and funders also have to have a sense of their own personal interests in terms of when to get out and when to just say this case is going poorly, but it's going to go even worse if we don't get out now. Right. And so a lot of that is about sophistication and the ability of the funder or the plaintiff to kind of know what's happening. For defendants, it's generally about seeking discovery to understand it so that they can get to a decision and settle. I've heard repeatedly in the IP context of defendants saying, I wish I had just known up front because we could have settled this in 6 months for the same amount of money. If I knew who the counterparty was, if I knew who I was talking to, and if I didn't just sort of have to go through the motions of paying for discovery and litigation, and the case seemed artificially extended because of that, or alternatively, why there was so much settlement pressure up front.
Can you give a more concrete example of that, Jonathan?
Which one, of fast settlement or slow settlement? So I'll give an example.
Well, one of each.
Yeah, so there's a portfolio funded entity that has funded multiple campaigns across portfolios against large defendants. Some parties who didn't know it was funded were settling with each individual defendant, and they just kept coming, right? And a more sophisticated party recognized that they were all funded and part of a fund and went to the entity and paid them a very large number, but settled with the ultimate entity and got rid of it and solved the risk problem in a much more efficient way without having to involve the courts, without having to do this. So that's an example of the knowledge being a little bit frustrating. If the case is underwritten to sort of assume that it will go to trial for some reason, that may be counterintuitive because there may be a really good settlement offer on the table early and the funder just says no because the way the agreement is written, it doesn't actually benefit them. Alternatively, if they have documents and underwriting that suggests there's a 6 to 12 month settlement window for certain things and they need that money for their fund time to trial, and they have some artificial settlement time horizons, you may find that the plaintiff is like hungry for even a lower settlement that doesn't make sense and you don't understand their behavior and you say, hey, like, you know, they're actually wrong about this, or we could get, and for some reason there's this artificial pressure that may come just because of the way the agreements are structured. What's key to remember about all litigation funding is that these are very smart people who are investing a lot of money who try their best to predict the future, but nobody can predict every single outcome of the idiosyncrasies of litigation, right? So they have very complicated agreements usually that try to anticipate what's going to happen. But if there are decision points along trial that radically change the case outlook or the case outcome, you're kind of in a new world with an old agreement, right? And that can make it much harder to settle things when things go awry or when things change their trajectory in the course of a campaign.
So, so Jonathan, doesn't this really call into question who is really making the decision and the autonomy of the parties? Who is really making the decisions here? And from an ethical perspective, is that okay? And who should be making the decisions as to settling cases?
Yeah, it's a great question. So the policy discussions around litigation funding, and I think a lot of the, let's say, pushback from judges or pushback from parties that I've seen have boiled down to questions of control or influence over the settlements. I was at a conference where a judge said, I had two parties before me and I thought they were going to settle, and the party said, I don't have the authority to settle this. And it was a question asked of a funder. They said, how is that not control? That sounds like control to me. And if they have control, then they should be a necessary party to the agreement. Litigation funders see themselves as passive investors and see themselves as non-parties, but they have a fiduciary duty to manage their investments. And that conflict between the, in theory, arm's length relationship and lack of control versus the need to influence and control is where the rubber meets the road. And it's why a lot of people, particularly in the settlement context, hone in on whether all the parties are in the room, right? Whether the funders are a real party in interest or whether they should be a necessary party or not, they may have enough influence or at least enough skin in the game that a mediator or a judge may demand that they be there, because otherwise it's sort of an incomplete settlement negotiation. And I've heard of judges sort of on an entirely voluntary basis, right? Like asking them to come in and say, like, you should be here because otherwise, what's the point, right?
And then who is they? Because you have
Mhm.
the litigation finance company, and then you have the various investors in the fund. So
That's
who
right.
compromises the they who ought to be there, if
Yeah,
in fact somebody ought to be there?
it's a great question. These are all very complicated. Generally, funds have LPs, like limited partners, who have n no control over the fund. It's sort of like a private equity model. And so they probably don't need to be disclosed just because they have literally no control. Although for conflicts purposes, you may want to know who the LP investors of a fund are, right? There are some courts that go far further, to your point, up the chain. Delaware has a judge named Judge Connolly, Chief Judge Connolly, who has demanded disclosure of all LPs and all invested individuals. There have been cases that are before him where you literally see a disclosure of tons of family offices and tons of pension funds that are limited partners in a particular fund. I'm not sure whether that's necessary legally, but there are people that think that that's necessary. But the general partners, the litigation funders, are probably the only ones that are going to have the agreement in place and the ability to actually influence, or at least the check-ins and the kind of ongoing relationship with the claimant. So they're probably going to be the most necessary party. But for conflicts purposes, I guess it would be really nice to know, let's say that you were a let's say that you were a Bush, right? And you were a judge, right? Like, or you were married into the Bush family. The Bush Family Foundation donates, not donates, invests in these things. University of Southern California's pension fund, right? Lots of organizations that there are judges out there that are wealthy enough to personally invest in, right? Or that have familial ties or have worked with them or whatever. And it'd be nice for conflicts to avoid the sort of appearance of evil. So, but it's an open question, right? I think right now people are primarily concerned with the identity and disclosure and presence of the general partner, the litigation funder themselves. But there are others that would go further. And to that point, I think one of the things defendants like to seek is court oversight of some of this, which can make judges and mediators and sort of de facto regulators. I think courts are a little bit uncomfortable with this, but oftentimes they'll say, look, if they claim they can't show me their litigation funding agreement or they claim they can't disclose this on work product privilege, I'd like to ask you, judge, to ask them the questions for me
Mhm.
in camera. I see a hand up.
Yeah, let's have a couple. I think David had his hand up first.
Yeah,
Yeah.
this follows on Jeff's question about who's making the decision on behalf of the fund or the GPs. What does
Mhm.
the infrastructure look like within these firms to evaluate these cases, make determinations around how much to invest, the timelines, the settlement figures? Is it lawyers? Is it bankers? Is it a combination of all these types of knowledge workers?
It's generally a combination. There are different examples of like Ponzi schemes and things that have happened that like, we'll just throw out, right? Because that's but like there's a traditional model of the successful firms. It's approached like private equity with the presence of lots of lawyers. I have friends that now work for Burford or who work for Curium Capital or whatever. So they're no underwriters for this type of thing, but they do have lawyers analyzing the cases that come in to potentially invest. They probably, like most private equity funds, have a worst case, best case, neutral case in terms of case outcomes. And then they claim repeatedly that they invest in maybe one out of 100 people that approach them for funding, right? So sometimes they have lawyers at firms bringing cases to them. Sometimes it's claimants. Sometimes they're going to find claimants, and sometimes there's already a class that's been put together that's seeking funding, right? Where like a lawyer at a mass tort case may know that they can fund a case or that they can put a case together that would take 5 years, but they need funding, and so they'll just go to 5 to 6 funders if the funders haven't already approached them and do an analysis phase. Usually it's kind of like a 30 to 60 day, might even be 3 to 6 month like exclusivity period where they analyze the case, decide to invest in it. Some of them are on much faster timelines. So I see another question.
Yeah, Lonnie, please go ahead.
Yeah. Hey, Jonathan, great program. I'm gonna say the quiet part out loud because I think I heard you say something that really stunned me. And it's not really stunning, but in a way it is stunning when we juxtapose it on mediation.
Sure.
You said that these funders have a number by which they need to make. Otherwise, they can't settle the case, which is why these cases tend to go to trial more. That seems to me, right, in my humble opinion, like the antithesis of mediation, where you're supposed to not have a last, best, and final when you get to the table, right? If every
Right.
mediation starts with, if I don't get X, I'm leaving. And I understand that that is the posturing that often happens. But in this case, it seems like it's an actual number and there's absolutely no way they're going to accept something lower, then it almost begs the question, why go to mediation if the defendant, and I'm just going to use plaintiff defendant, isn't willing to meet that number? And it feels like you don't really need mediators anymore, right? You just say, all right, here's the number I need. If not, we're going to trial, buddy. And
Yeah.
it seems wrong. It seems wrong to me. I don't know.
So I've heard that echoed by others, and I understand the concern. I mean, if I'm trying to be neutral here, what I would say is that people have irrational settlement expectations all the time, pre-existing rational or irrational settlement expectations all the time. There have been cases like I think everybody remembers a civil action, right, where there were multiple cases along the way in the John Travolta movie and the book that's based on a real case where there were settlement offers on the table that seemed reasonable that they said no to, right? They pushed it higher and then the whole case fell apart. I mean, I think parties' behavior is idiosyncratic or it's syncretic for different reasons, right? All I want is an apology or I want $100 million. There are people that make these decisions all the time outside of the context of litigation funding. So um, I think that behavior is guided by the type of investment, and it's a lot of money. It's a big coin flip, it's a big risk that they're taking too. So I won't speak to like the broader policy implications of that. I will say that one thing that funders have probably started to do, and I've seen in some agreements, is they've tried to make sure to be aligned with the plaintiff and make sure that if there is mediation, it's in a sort of helpful or a way that like hopefully isn't upsetting the mediator or upsetting the court or upsetting the court's time and they feel like it's useless. But again, putting that aside, outside of the funding context, I'm sure every mediator here has been in 100 mediations where there was no funding and it was just two parties and there was a reasonable settlement on the table and they all said no for no reason at all. Right. So I'm sure that idiosyncratic behavior is not isolated to litigation funding. But I hear what you're saying, and I think it's a good point.
Jonathan, we have a question from Fiona Cheney. Fiona is a senior executive with Omni Bridgeway Litigation Funding Company.
Yeah.
So
Hey,
Fiona,
Jonathan.
please go
Hey,
go
Fiona, how's
ahead.
it going?
Welcome.
Hi, thanks, Jeff, and thanks, Jonathan. And Jonathan, I didn't know if you'd mind if I provided like a little context from the funder side.
Not at all.
I'm not
Happy
trying
to.
to
Yeah. Yeah.
steal your show, but I just wanted to
Okay.
make a couple points. Like first on the control point, right? Like so we very explicitly, and I can only speak for Omni Bridgeway. I've seen some other, funding agreements in the public domain, but at Omni, I mean, we explicitly disclaim any right to control the litigation. And as far as settlements go, one thing we do, and we tend to work with, sophisticated parties on the other side, but we will, before we agree to invest anything in a case, we have very upfront conversations. We provide our counterparty or potential counterparty with a like client-facing model that shows them, right? Like maybe if you're going to settle, here's the ranges, here's what you're looking at, here's, what this looks like. And quite frankly, if we, are looking at a potential investment where there's not good alignment, right, where they're not going to be able to settle and they're going to have to go to trial to see anything, we won't invest in that case because obviously trials are inherently risky. And so we really do try to solve for that in advance. Like we really, you've used the word like evil a couple times on this call, and like I kind of find that a little offensive, because we really do try to be thoughtful and considerate investors and really understand, all of the issues and all of the alignment at play. And again, we do a ton of underwriting on these cases before we agree to invest, both on understanding the damages, understanding potential settlement dynamics, as well as underwriting the merits of the claim. So, it is a very thoughtful and intensive process. So I just wanted to put some of that context there.
Thank you.
Absolutely. Yeah, I think it's a very good point. It's very well taken. I don't remember saying the word evil, but if I did, I apologize. It was not intentional. And if it was, I was probably trying to put it in the context of some of the debates. But obviously, it is a very serious business to put a lot of money up into these agreements, and a lot of thought goes into it over a long period of time, just like private equity and just like other types of large scale investments. And so I think most of the sophisticated funders are doing everything they can to prevent these types of disputes that happen later, this lack of alignment or other things that we see. I have examples in here, but I'm not going to go into them because there's too much to talk about of when it has broken down. But I think it's important to note, probably just larger from where we are, is litigation funding has definitely come out of its infancy in the United States. It has been around in some way, shape, or form for over 30 years in certain states and what have you. But the last 10 years, it's definitely seen an upswing of it. We have publicly traded companies like Omni that litigation funding is their bread and butter here and internationally. And it's something that is, if you'd gone to a conference 5 years ago and you asked people what litigation funding was, you'd get a smattering of hands, right? If you go today, most people know what it is or are still trying to understand it. Unfortunately, because the agreements are usually not public, and just like private equity, like there's not nearly as much disclosure as there's in the public markets. What you get is a lot of the information that leaks into the public is because there's a dispute for lack of alignment. And so you have these very large cases that grab headlines or that are on 60 Minutes or that make it into the media that sort of are worst case scenarios. So it does happen, obviously, right? Like there was a large case in Europe, not here, where a funded entity funded a MasterCard class action. They call it a collective action there. The lead claimant decided they wanted to settle for $200 million, but that was low enough that the fund wasn't going to make their target investment. And so that fund put the claimant into mediation to try to fight the settlement and did it in the collective action tribunal in the UK. It was going to be $10 million for that arbitration. And MasterCard actually chose to fund the claimant's mediation with the funder to form the settlement. So just in terms of like the breakdown of alignment to the point where you have the defendant aligning with the claimant to try to force the settlement in that one case. These are the types of stories that come out because they spill out into the public because of the sort of lack of alignment or the cases breaking down. What you don't hear, and what you're probably never going to hear in a lot of cases, is the success stories where people couldn't have brought a case and came to them. They funded the case. It went successful. Everything was fine. Those are the boring things that are not disclosed 9 times out of 10. So To be fair, I just want to be fair on that. I mean, I know we're on one side of this debate, but I think that that's sort of like the drunk, the guy's walking around at night and he sees a drunk under a lamppost and he's like, "What are you doing?" He's like, "I'm looking for my keys." He's like, "Why are you?" He's like, "Can I help you look?" He's like, "Well, they're over there in the dark." He's like, "Well, then why are you looking over here?" And he's like, "The light is better over here," right? Like we see what spills out into the public, right? Because that's where the light is, but we have no idea, the extent of the industry. We have no idea how many of these cases are successfully funded and the claimants are end up happy and justice is served and all of that. And until there's sort of broad scale disclosure, we may not know. So, David, do you have a question?
Yeah, I was just going to say, I think your point speaks to this, a broader question about what's the larger potential social good behind the existence of this industry as well. I mean, you mentioned the litigation funding of some of these AI large language model cases, and I think we've all seen out of the Northern District of California the landmark $1.5 billion settlement, I think, in the Anthropic case, and
Yep.
I think Sussman Godfrey was involved in that case, and
Yep.
from the LA entertainment sort of perspective and the artist creation perspective, they probably wouldn't have been able to bring those cases, obviously. And you
Yeah.
ask yourself, how is it possible to even churn through these data sets? And what is the cost and the expense associated with the analysis that these firms have to do in order to bring these cases? And it's staggering, right? So the presence of funding, in some sense, has really helped push the frontiers and the boundaries of what the law should be in these areas. But I can't help wonder, at the same time, these PE funds are behind a lot of AI companies also, right? So just the complexity of the hedging and the analysis that must go into what cases we should take and what investments we should make is just, I think it's just fantastic to think about.
Yeah, I mean, I'll just close by saying like I'm agnostic. Like it's here, right? And it's part of the fabric of what we do now, right? And so I mean, in my private life, I took classes from Andy Popper at American, who was a PE, a PI, sort of personal injury lawyer for a long time before he was and that was sort of my training. And I see the inherent value of the justice system and the fact that there's all this money involved in it and it can bring justice. I co-taught a class with one of the general counsels who's a named plaintiff in the Bart's case, or at least a necessary party, the American Music Association or a Publishers Association. There's going to be examples, right, both ways. I'm more here just saying like this is here. It's interesting. It's certainly affecting mediation, and it's something that we should all kind of educate ourselves about because I think it's certainly not going anywhere.
Well, Jonathan Stroud, thank you so much. Litigation funding is here, and we're so glad you were here because this was really a wealth of information, tremendously practical and useful for all of us who get involved in the mediation potential settlements of these cases. Jonathan Stroud of Unified Patents, thank you so much. I hope that people will be motivated to contribute to Martha's Table, marthastable.org, in your honor, or any other food bank. Every food bank is worthy in your honor. And we appreciate it very much. Thank you so much for an excellent presentation. And with that, we are complete.